I invite Honourable Justice Neerooa Azam, PUISNE Judge, the Supreme Court of Mauritius, to deliver his response.
So, my lord, I concur with your speech in its entirety, but I guess I cannot start and end my response by merely stating this. So, first of all, I'm very humbled and at the same time honored to have been invited by Dr. Nauman to react to Lord Reed's lecture today. I extend my gratitude to Dr. Nauman for this opportunity. All of us can only sincerely hope that the GSN network continues to expand its areas of activity, further strengthening its impact and reach. Lord Reed has outlined the essential and relevant aspects of the already existing judicial cooperation between the UK and the Global South. And it was very inspiring to hear that the UK continues to help and act as a torch-bearer for the Global South in matters of judiciary. We can only benefit from the very long and rich experience of the UK judiciary and its legal jurisprudence. The UK and Mauritius has a very strong judicial cooperation, the main reason being that Mauritius still retains the constitutional rights of its citizens to appeal to the JCPC. Hence, the JCPC is the highest court of appeal of Mauritius. We have largely benefited from the very rich binding precedents from the JCPC, which has a deep and decisive effect on our judicial reasoning in our everyday judicial work. This constitutional right to appeal to JCPC gives Mauritian public, as well as would-be foreign investors, a sense of confidence in our judicial system. Having the JCPC as the apex court of Mauritius no doubt strengthens rule of law and acts as a powerful check and balance to the judicial system in Mauritius in terms of judicial accountability, from a completely independent and impartial source, far from the shores of Mauritius. This judicial cooperation can no doubt be further enhanced. For instance, the JCPC may be composed of one local judge whenever hearing a case from Mauritius. And here, I can only thank Lord Reed, who has been the architect in successfully convincing the UK government to allow justices from across its jurisdiction to sit as part of the panel. An immediate consequence of this very welcoming initiative by Lord Reed is that the local judge will bring his or her local expertise as well as share the local knowledge and conditions, which will only help develop a better judicial cooperation in the judicial decision-making process and enhance the judgment of the JCPC. Another effect of this reform is to address the argument that allowing the JCPC to decide on local cases amount to a compromise of sovereignty, with one of its local judges forming part of the panel deciding cases from its jurisdiction. This argument would hopefully have no effect whatsoever. On another note, it is no secret to anyone that the legal cost to appeal to the Privy Council is very high, and very often acts as a barrier to a litigant to explore the avenues of appeal, even if his case is very strong. Reviewing the legal cost related to appeal to JCPC could be seen as a big step forward towards making equal access to justice for all a better reality. Nonetheless, it is only fair to say that there is already a very healthy judicial cooperation between the United Kingdom and Mauritius. As regards the present topic, Lord Reed has extensively highlighted the importance of judicial cooperation in relation to matters of substantive law. I would like to emphasize on another area, that is the perception of judicial system today and new challenges facing judiciary around the world. There is a wide perception indeed, which is growing and a reality already in some jurisdictions, that there is a lack of public trust in the judicial system. It is fair to say that this is a world phenomenon affecting both the North and the South. The obvious reasons are the following. First, administration of court has been saturated since a long time and needs fresh air. Complaints of backlogs in case hearing and its outcome has become a common feature. Inefficient procedures leading to exceedingly long proceedings, poor management practices, lack of communication skill of the judiciary, amongst others, have long been at the forefront of criticism against the judiciary in most parts of the world. Second, there is an ever-growing worry that the independence of the court system is being gradually eroded due to political interference and corruption, or at least a very strong perception that this is the case, together with a lack of transparency and accountability. Third, it is becoming a constant complaint that access to justice is being denied, particularly to the most vulnerable groups of the society, such as the minority groups and the very poor. There are no doubt other problems, for example, the mode of appointment of judges and related security of tenure, which has an incidence on the independence of judiciary. Another disturbing reality in the performance of duty of a judge today is his personal security. Not so long ago, a magistrate was shot whilst in court by a police officer in Kenya, whereas only yesterday, you surely must have heard of 2 Supreme Court judges in Iran shot dead inside the court premises. It is in this particular context, I believe, judicial cooperation between North and South becomes crucial, since, as Lord Reed has emphasized in his speech, a commitment to justice and the rule of law is a shared priority of judges around the world. And sharing knowledge and experience amongst the judicial actors of the North and South becomes a relevant aid to strengthen the rule of law throughout the world and establish the best practice. This is, I believe, the true aim of judicial cooperation, so that the new difficulties which the judicial system is facing may be resolved. Surely there must be jurisdictions which have already tackled some of the problems highlighted earlier, and therefore their experience would be a valuable guidance to other jurisdictions which are facing the same evils in their judicial system today. To conclude, I can only reiterate my pleasure to have heard Lord Reed highlighting how the UK judiciary has been helping the other jurisdiction in various areas of concern. Such judicial help can only be welcomed, so that there is a better future for the judiciary everywhere in the global North and the global South, or rather, should I say, the global village. I thank you for your attention.
Thank you very much, Honourable Justice Neerooa Azam, President Judge, the Supreme Court of Mauritius, for your response.